Welcome back to Immigration Insight, where we dive deep into real-life immigration stories and the strategies that helped our clients achieve their American dreams. Today, we have two incredible stories that showcase how creative problem-solving and a thorough understanding of U.S. immigration laws can turn seemingly hopeless cases into success stories. Joining me is our very own Shah Peerally, attorney extraordinaire. Welcome, Shah.
Thank you, Harry. It's great to be here again and share these cases that really highlight the power of the law when applied correctly.
Let's get right into it. Our first story is about a client, Mr. R, and his family who found themselves in a dire situation after Mr. R's H-1B transfer was denied. Can you walk us through the case, Shah?
Absolutely. Mr. R came to us in June 2007, and he was devastated. His H-1B transfer had been denied because USCIS believed he was overqualified to work for a small company. To make matters worse, the company he was working for was closing down within a month, and he had no time to secure another job. It was heartbreaking because this was someone with an impressive resume, a patent to his name, and a lot of talent.
That sounds like an extremely difficult situation. How did you approach it?
It was indeed. I sat down with Mr. R for 2 hours, going over every possible angle. Initially, we considered filing a motion to reopen or appeal the H-1B decision. But upon deeper reflection, I realized something. His curse of being overqualified was actually his blessing.
Interesting. How so?
Well, being overqualified suggested that Mr. R might meet the criteria for a National Interest Waiver, or NIW. After carefully reviewing his qualifications, I concluded that he could actually qualify for this category, which doesn't require a job offer. However, there was a catch. Since NIWs fall under the EB2 category, the visa dates had to be current. Mr. R was from India, and unfortunately, the dates were retrogressed at that time. But in a stroke of luck, the visa bulletin for July 2007 indicated that EB2 for India would be current.
That's incredible timing. So what happened next?
We acted quickly. By early July, we had filed his NIW petition along with his adjustment of status, or AOS, and applications for advanced parole and a work permit. 6 weeks later, Mr. R received his work permit. By December 2007, his NIW was approved. And finally, in 2010, when the priority dates became current, Mr. R and his family received their green cards.
That's an amazing turnaround. What do you think was key in this case?
The key was looking beyond the immediate problem. Instead of just focusing on his H-1B denial, we saw the potential for a completely different path to success. That's how we approach every case at the Shah Peerally Law Group, by finding the best possible solution, not just the most obvious one.
For anyone interested in learning more about national interest waivers, head over to www.peerallylaw.com or give them a call at 510-742-5887. Now, let's move to another case that emphasizes preparation and calm in the face of stress. This is about Client D, who faced an unexpected employment-based interview at USCIS. Shah, what happened in this case?
Client D was applying for his green card through the EB2 category. And typically, EB adjustment of status cases don't require an interview. However, because of a past domestic violence charge, which was ultimately dismissed, he was called for an interview. He was extremely stressed to the point where he needed therapy.
That sounds overwhelming. How did you help him through this?
First, we conducted a detailed interview and advised him on what to expect. Although there was no requirement to submit a legal analysis, we decided to provide an advisory opinion about his case to the USCIS officer ahead of time, addressing any potential inadmissibility concerns. This was mainly to put the client's mind at ease and minimize the time spent at the interview.
Smart move. How did the actual interview go?
Well, things took a turn when USCIS couldn't find the approval notice for his I-140 during the interview. That really panicked the client. But I was able to speak with the officer, and thankfully, she went out of her way to locate the document. She approved the case on the spot.
That must have been a huge relief for your client. What was your takeaway from this case?
This case highlighted the importance of staying calm and being thoroughly prepared. It also showed how essential it is to have a law firm that's responsive to a client's individual needs. Client D's previous law firm wasn't able to provide the support he needed, but our team was able to step in and secure his green card.
It sounds like your expertise made all the difference. For more information on employment-based immigration interviews, visit www.peerallylaw.com or call 510-742-5887. That's it for today's episode. A big thank you to Shah Peerally for sharing these success stories. As you've heard, navigating the immigration system can be challenging, but with the right team, anything is possible. Until next time, this is Harry, signing off from Immigration Insight.